Professor. That's my name.
Hi, and welcome. I'm John Rizvi, the Law Firm Growth Professor. And for my new listeners, I'm pleased that you've come to join me today. For my returning listeners, it's always great to have you. In this podcast, I share the strategies for growth that have worked for me in growing my law firm from a startup with just me, a laptop, and a cell phone operating out of a spare bedroom to where we are today, a team of 60 professionals generating over $10 million a year in revenues from our 10,000 square foot headquarters in Coral Springs. Today, I want to talk about a big problem that a lot of attorneys run into with their SEO agencies, but nobody really talks about this problem, and that is contracts. We don't talk about how a good contract versus a bad contract versus a mediocre contract is when it comes to SEO, or how they look, how they work, how they operate, and how they protect your interests, as well as that of the agency that you're working with. The problem is that a lot of SEO agencies don't have legal counsel on their staff and don't see an attorney. What they do have access to is LegalZoom and ChatGPT, and they find these copy and paste contracts on the internet, and that's what they use. And then they just tweak the terms to the point where they think they're going to stand up. The obvious problem with this is that not all contracts are created equal. Those of you who work in contract law will be very familiar with this syndrome. Not all attorneys, of course, deal with contracts in any serious or meaningful way. So it's easy for us to fall into this trap of thinking, well, I'm an attorney, I've got a law degree, I've studied contracts, so I can tell a good contract from a bad one. And you only find out that that's not the case when you've got the contract in hand and the problem, and your SEO agency is directing your attention to a clause that you overlooked or didn't think would apply. And now you've got a mess on your hands. And of course, they're not going to help you beyond what the letter of the contract states. So this puts you in an awkward position with regards to your SEO firm. Of course, a good SEO firm will write a good contract, one that's fair, balanced, and reasonable, and clearly spells out their obligations, their key performance indicators, and the other things that you need to have in place to feel like you have a proper working arrangement. On the flip side of that, of course, you have bad contracts that basically give away the farm and say, yes, you're giving us business and that's great, just don't expect us to help you out on the back end when you have a problem. So knowing this, we need to ask ourselves what a good contract looks like. Is there a way to get out of it if you need to? And is there a way for them to get out of it if they need to? Are the terms fair and equitable for everyone concerned? Now, a lot of contracts from SEO agencies are not good contracts. Why are they not good contracts? Because these contracts are designed specifically to keep you locked into an agreement with them for as long as they can possibly do so. Now, there's some standard boilerplate terms that have to be there in almost all SEO contracts. But again, you can't trust that you're dealing with a company that took the time and the investment to hire an actual attorney to review their contracts to make sure that they would hold up. You're going to have to do a little bit of due diligence here, because otherwise you'll find yourself locked into a long-term contract with a company, even if they basically stop helping you as soon as the ink is dry on the contract. And then say, if you that we'd like more money, please, and it's the first of the month, and they're going to ask for their next month's payment. That's frustrating. And unfortunately, many law firms have gotten a bad taste in their mouth about SEO, not because SEO doesn't work, but because the contract terms that they signed were garbage. So it's understandable that they would be frustrated. It's understandable that they wouldn't want to risk finding themselves in the same situation again. And of course, it's not profitable for most attorneys to go after most SEO firms for malpractice or failure to comply with the contract, because they probably don't have the assets in place to be able to effectively pay out a judgment, even if you get one. So one of the first things you need to be looking at is how long the contract locks you in for. Is there an escape clause? And now a good escape clause should be like a two-way door. You can get out of it, they can get out of it. Instead of having one side say, okay, we're going to be locked into this contract for 12 months, 18 months, 24 months, whatever. Understanding how the escape clause works is very important. In fact, I would argue it's one of the most important things that you need to review and make sure you're comfortable with. If there's a locked-in term, that's fine. And that's not necessarily a warning sign that a bad contract exists. But where it becomes problematic is where there's a long-term clause, but there's no escape clause. There's no, if we don't hit these KPIs, or you don't realize this amount of revenue in this amount of time, then you have the right to terminate the contract early without penalty. That's another important thing. A lot of firms will bake in a kill fee, which of course is just an exit fee that you have to pay to get out of the contract. If they have a kill fee in their contract, it needs to go both ways if you want to back out. A good exit clause covers everybody equally, and it affords all parties equal protection. But a lot of firms will use shifty language. Of course, you'll want to understand that they deal in language similar to the way that attorneys do, but they have a lot more freedom to message the terminology, if you will. We don't do that as attorneys. That's not our bag. We're looking at compliance with the law and making sure that everyone's rights are upheld in a contract. SEO firms don't have that concern. They're not regulated by a state bar the way that we are as lawyers. And they have enough time to work on the language so that they can imply that it applies equally, but just as easily turn around and say, yes, but here's this sentence that you overlooked that says we don't have to pay you a kill fee, or, obligate you to pay them a kill fee. So you need to think about that. You need to be very aware and very focused on making sure that if the contract says one party has this responsibility, the other party has these rights and responsibilities in response to that section. Another concern that I run into a lot is not having the KPIs spelled out well. It should be very, very clear to everyone involved in drafting the contract what the intended outcomes are before you ever sign. If you have a firm coming at you on day one before they've even looked at your site and they're handing you a contract, you've got a problem. Why? Because these people are so desperate to get you signed on the dotted line that they're willing to say or do anything. They may say something like, oh, this is standard boilerplate, or this is a template, and we'll put in all the negotiable terms later. No, absolutely not. Your contract should include what's expected. What are the KPIs? What are the markers for having met those KPIs? And what will happen if those KPIs are not met? Now, of course, you may remember I've talked about this before. In the world of SEO, we cannot guarantee results. I've also talked about the fact that we as attorneys also cannot guarantee results, but we like to have those guarantees in place when it comes to our affairs, which is reasonable, because nobody wants to be surprised. No one wants to be blindsided. This is understandable, and everyone who deals with contracts in any form will readily understand why this matters. So you want to make sure that the KPIs are in there and that they're clearly stated. For example, if you're looking for more traffic by 3 months, well, what does more traffic mean? If you're looking for 5% over the previous month on an ongoing basis, great. Put that in the contract and maybe make it at least 5%. If you're looking for a verifiable boost in subscribers and people coming into your firm seeking advice, which of course ultimately translates or is supposed to translate into paying clients. In that case, that needs to be in the contract. You need to be clear on the fact that just because it's in the contract doesn't mean that it's a firm deliverable that your SEO firm can make happen. That's where a lot of people get tripped up because they think, well, we had a contract. But SEO is fickle. You cannot guarantee results on SEO. Even Google says anybody who promises you results like guaranteed, actionable, verifiable results is probably doing something you don't want to be involved with. And it's probably something that at some point could wind up getting your website penalized or worse, even taken down. You don't want that. So there also needs to be a clause about ethical business practices. White hat and black hat SEO needs to be covered. And you need to make sure that they're not, say, using black hat SEO, or they're not, for example, buying batches of backlinks to your site. For attorneys, this stuff gets real serious real quick, and it could cause a lot of problems. In fact, even with your state bar association, if you're not careful. So you need to have that protection in place, and you need to have language and the boilerplate ready and available so that it's clearly spelled out as far as what will happen, what the timeframes are, and what the consequences will be if those KPIs are not met. The next thing you need to do is you need to have a clear scope of work, because one thing that SEO firms hate is scope creep. You sign on with an SEO firm to deliver A, B, and C. Well, okay, that's baked in the contract. There's no problem there. But a lot of clients over time will try to move the goalposts or say, hey, can you, in addition to this thing I've already contracted you for, can you also do this? Well, if that thing isn't covered under the contract, the SEO firm is going to say no until you've drafted another contract that stipulates all of these new goals and mechanisms are in place. And yes, there will probably be a commensurate raise in fees. Not necessarily in some cases. Let's say you're starting out brand new, you have no website, you have no online presence to speak of. In that case, you've got a blank slate. So you've got all these opportunities for social media, website building, and website development. And during that part, yes, it's probably going to suck up a lot of money, because it's one thing to go over and do a facelift on an existing website, and it's an entirely different matter to take a website from zero, bring it up to full speed, ready for public deployment, and ready to start getting you clients. The same applies to every single social media channel that you have. You may restrict yourself to LinkedIn and Facebook, and that's fine. But your SEO firm, if they're any good, will strongly suggest that you also add Twitter and Reddit and Quora and all of these other social media outlets, Instagram, things like that. So you want to be prepared, and you want to make sure that every single thing you need done is listed in the contract, because what you don't want to happen is, oh, well, I contracted for the website, but I didn't contract for the web development that it takes to bring the website up to the proper function. Or you have the basic architecture in place, but you don't have an actual web developer to work on it because you said, I'd rather do that part myself and save some money, which again is understandable. And a lot of people can do that fairly well, especially with the advent of sites like WordPress and even GoDaddy, where they have platforms that can let you build a website, host it, and it's pretty self-contained and user-friendly. The only question then is, how much do you want to spend on the plugins? That's another thing you have to consider. The cost of plugins and add-ons and additional services, they should be baked into the contract. If it isn't, they can tell you, no, we're not going to do that because it's not in the contract. And there's actually nothing you can do about it. That would be frustrating. So you want to make sure that you have all of that in place as well. So now you've got terms of a contract, you've got escape clauses, and what exactly is included in the contract? That's spelled out as well. The next question is, how do you know that you're getting a bad contract? If all of these things appear in place, well, one bad example of a contract is expecting a turnaround of 24 hours. I know a guy who does that, and he's done it quite well over the years. However, it's not his preferred way of operating, so you need to make sure that the time frames you're stipulating are reasonable. You may spell out that a working day is considered Monday through Friday, unless they take other days off, such as religious holidays or birthdays or events with significant others, things like that. And that would be reasonable. Now, if you got somebody who may nominally work Monday through Friday from 8 to 5, but every single time you turn around, they're on vacation, that's not a good sign either. And if it's not covered in the contract, you have the right to call them out on it and question it. Now, of course, we all understand emergencies happen, things fall through the cracks, but that sort of thing, of course, contracts can't always cover. Although it would be good if more SEO firms baked some kind of boilerplate language into their contracts, especially if they're smaller agencies, to account for things like vacation times. And that would make it a lot clearer to everyone exactly what needs to be done and what the options and consequences are for not getting it done as specified. Another huge red flag that you need to be looking for is, are the fees reasonable for what you're asking? If you call up or email a firm at 9 a.m. and you say you need this content for, say, 1,000 words or whatever by 5 p.m. tonight, most SEO agencies would rightfully consider that a rush order if there's not boilerplate language about rush orders and what they cost, or emergency orders that basically mean we're going to drop everything and we're going to work on this right now, no matter what else is going on. However, we do charge a premium for that service so that you get it done. And if, say, you're in the middle of your kid's birthday party or on vacation or at a funeral, there has to be an understanding that that's taking away from personal time to address this. So yes, it's going to cost more. I know a guy who does that and has what I think is a pretty reasonable rate. He adds 25% for rush jobs and 50% to 100% for emergency jobs, depending on how the job is structured, what needs to be done, and how long he estimates that it's going to take. You know, if you're talking about something he can research in an hour, write in another, and have back to you, he's generally not going to stick you with a higher emergency rate. But if you need a 10,000 word white paper and you ask for it on Friday evening and you need it by Monday, well, now you've cut into his weekend, so his contract should reflect that and reflect the cost to the personal time and the impact that it has on that. I think that's just fair and reasonable. And of course, if they give you a great result, it's worth your while to work with them a little bit on things like that. Now, that's not to say that every contract is great, and not everybody is going to clearly spell out things to that level of detail, and that adds a lot of burden at the early stages of the relationship. But if you have somebody that you're working with and they've been in the game for 15 years, you're familiar with them, you know the quality of their work, you can relax on some of these aspects and not have everything spelled out. And a lot of SEO agencies, they don't think about this stuff, or they figure, well, it's not going to matter because our business hours are Monday through Friday, 9 to 6 p.m. or whatever. So you need to think about this in advance, and you need to look at the contract you have with your SEO firm. And if you have one, you need to see that these things are in place and that they do seem fair and reasonable to both sides. One last provision I want to talk about, and this is one that really puzzles me, that most people don't insist on, and that's to make sure that there's a clause that states what you're expected to know, have, and provide to accomplish this contract. You may say, I want to buy all the plugins myself. Okay, fine. Then that should be in the contract. You may say, okay, I want to make sure that I'm giving them the information they need to be able to do the job. Nothing will irritate an SEO agency more than having somebody say, oh, I need you to write 5,000 words on this subject, but I'm not even going to give you a starting point, an article, a snippet, a social media comment, or something. But all of that should be in place. So make sure you review your contract and make sure it's in there so you can feel secure that you're setting yourself and your SEO agency up for a successful partnership. Again, I'm John Rizvi, the law firm growth professor. Before you leave today, I'd appreciate it if you could click the like button. Make sure you subscribe so that you don't miss any updates from this channel. And don't forget to share this podcast with your friends and colleagues who are attorneys. Thank you so much for stopping by, and be sure to tune in next week when I discuss online reputation management and why it matters so much to your law firm. I look forward to seeing you next week.
So when a new idea pops into your brain, call the patent professor. That's my name. I'm a law school professor. An engineer too. I think math is fun and patents are cool. If the patent office says your idea's not new, that's just red tape that will cut right through. So when a new idea pops into your brain, call the patent professor. That's my name.